In this part two, we are going to cover the land records, the record of rights, which have been maintained under the Maharashtra Land Revenue Code. We are going to cover the Register of Charges, which is maintained by the ROC under the Companies Act 2013. And we are going to cover Schedule 1, which is maintained by the Charity Commissioner under the Maharashtra Public Trust Act. Now, what are the land records and records of right? The Maharashtra Land Revenue Code provides that the land records and records of right, they are maintained for the purposes of the Act, that is for the collection of the land revenue. The record of rights give details such as the persons who are the holders, occupants, owners, mortgagees, or a government lessee, or a tenant. What is the nature and extent of the interest of such person in the land that they hold, and what is the rent or revenue which is payable in respect of this land. For the purposes of due diligence, there are certain forms that should be looked into. That is Village Form 6, that is Register of Mutation Entry. Village Form 6A, that is Register of Disputed Cases. Village Form 6A, Register of Heirship, and of course the 712 extract, that is the record of right and registration of the crop. Village Form 6. Now, what happens is when a person, he acquires any right in the land, now that may be by way of any mode. It can be by way of a sale document, it can be by way of partition or succession or any other mode. In that case, such person is required under the Act to report to a talati within 3 months of the acquisition. Now, there is an exemption is when the such acquisition takes place because of the permission of the collector, in which case this person is not required to inform the talati, or where the transfer takes place pursuant to a registered document, in which case the office of the sub-registrar of assurances informs the talati directly. Now, once the talati comes to know that there has been some transfer taken place pursuant to the above mode, he maintains a register of mutation. Now, this is maintained as per Village Form 6. As you will see on your screen, there is serial number 1, the serial number of mutation. Now, this is very much necessary for the purposes of 712 extract. When we see the 712 extract, you will know why I mentioned serial number of the register is important. The second column gives you the details of the transaction, like who are the parties to the transaction, what is the nature of the transaction, what is the sale consideration, and so on and so forth. Serial number 3. Now, this gives you the proper detail of your land, the title of which you are investigating, the survey number and the gut number, from which you will come to know, yes, this is in respect to the land that you are investigating title. And the last column is for the purposes of certification by the officers and any remarks that they have. Once the information is put in the register of mutation, talati, he informs all persons who are interested, the interested persons who gets affected by because of this mutation, and also in some conspicuous part of the village, he posts this mutation. Any person who has any objection raises his objections to the talati, and talati is then required to note down those objections as per Form 6A, Register of Disputed Cases. So you will see on your screen, he mentions the serial number of the mutation, which is there in his Register of Mutation. He also gives full particulars of the land and what is the nature of the dispute that has been raised by the disputing party. Now, as per the procedure, within 1 year, the revenue and survey officer has to decide by way of summary hearing, summary inquiry is held, and order is passed. Now, this order also gets recorded in the Register of Mutation, and thereafter the transfer takes effect from Register of Mutation to the record of right. That is your Form 7. Now, we have always heard Satbara extract in one go without realizing that Caste is like form 7 is one kind of a form, and Bara is the second form, that is form number 12. So form number 7 is the record of rights. As you will see on your screen, the first row gives you the complete description of the land. It gives you the village description, the name of the taluka, your survey, subdivision number. You come to know the tenure, whether it is an occupancy class 1, class 2. Class 1 is where you are the holder of an unalienated land without any restriction to transfer. Class 2 is when there are restrictions on transfer, or you are a government lessee. The middle column, the local name of the field. Now, this is what generally in the village people are used to calling the land. So therefore, the local name has an importance of its own. You get description about the cultivable area, how much area is cultivable. Non-cultivable area is classified in two parts. Class A, that is all rocky or hilly regions which cannot be cultivated, or class B, if there is any reservation for public purposes, for roads, that all gets notified in class B. Then there is description of the assessment, how much is the land revenue payable. The middle column, the Bhogwata Darachena, is actually the name of the occupant, the person who is sitting on the property. The rightmost column will give you the name of the tenant, whether he be a contractual tenant or he is tenant under the Bombay Land Agricultural Tenancy Act. And the one of the most important is this other right column. So what happens is if there is any encumbrance on the property, or if there is any charge of the bank, that all gets recorded in the other rights column. Next, we come to register of crops, that is the form 12. This register of crops will give you the details of the crops that are grown on the land and the means of growing the same, that is the means of water supply, who is the cultivator, what seasonal kind of seasonal crops they are. That you get from village form 12. Now, when you apply for the certified copy of the 712 extract, this is how you get the 712 extract. The topmost part is form 7, that is record of rights. The below form is register of crops, that is form number 12. I had mentioned to you all earlier, serial number of mutation is important. Now you see there are certain numbers which are circled. Now this is in fact the serial number mentioned in the register of mutation. Now pursuant to this mutation entry in form number 6, the changes are made in this column and the next, the middle column and the rightmost column. Whenever a name of a person is deleted, his name gets bracketed. Now I would like to invite your attention to the first line. The name has been hidden, but you see there is a bracket. So every time the name of a person gets deleted for whatever reason that may be, it gets bracketed. So this is the sample extract of the 712. Next we go to form 6C. Now what happens if a khatedar dies, that is the occupant dies, the heirs come forward to the talati and tell them, yes, we are the heirs. So columns 1 to 4 will give you the details of the khatedar who has died. 5 to 8 gives you details of the heirs. What is interesting to note that is the person who is in occupation of the land, the heir who is in occupation of the land, his name gets recorded in this middle column, that is Bhogwata Darachena, the holder. And the heirs who are not in occupation of the land, their name gets recorded under the column Itar Haq, that is other rights. So whenever you are dealing with a deceased khatedar, it becomes important to look at both columns, that is the name of the occupant as well as the other rights column. There are other relevant village forms like register of occupant class 2, where new tenure lands are names of the person holding under new tenure are mentioned. There is no register of non-agricultural land in village that is form 2, where any in village, if some land is used for non-agricultural purposes, the details are mentioned in form 2. There is form 4D, that is register of new Port Hissars. Port Hissars translation is actually new subdivision. If I am a holder of a larger land and I decide to sell a portion of the land, and of course there was initially one survey number, which then gets divided after I sale, and a subdivided number is given. Say example 250/1 to me and 250/2 to the new owner of the portion of the land. There are other village forms like register of tenants, register of persons other than the landowner. For example, when a crop inspection is done by Talati and he actually finds somebody else cultivating, so there is a procedure where they write the name of the cultivator in a separate register, and register of holdings, that is the khate utara. That is, if one occupant holds several lands in a village, all his holdings are mentioned in one place and a khata number is given to him, which is pursuant to form 8A. In city like Mumbai, where survey has been done by under section 126 of the Maharashtra Land Revenue Code, and a cadastral survey number has been allotted. And of course, it is a non-agricultural land. You have something called property register card. Now, how do you read this property register card? The topmost row will give you the details of your land, the street number, the ward number, cadastral number, lot and survey number. Interestingly, we still use lot and survey number. This survey was done by one Mr. Lawton in the year 1895 onwards, and we still use the survey number which he had done at that point of time, and collector's new number. Tenure of the land is mentioned under column 5, whether it is a leasehold land or a freehold land. The devolution of title can be understood when you read column 10 together with column 11. In column 10, I would like to invite your attention. There is a bracket A and ABC outside the bracket. Now, this bracket you read together with 11 bracket A. Now, this gives you the details of the document pursuant to which the names of ABC has been entered in column 10. It will become more easier if we do try it with the next name also, that is bracket B in the column 10, and read it with 11B. Deed number, that is the registration number with the sub-register of assurances has given, that gets mentioned. Deed of appointment of new trustee dated so and so from ABC in column 10 as continuing trustees of the one part, and B in column 10 as additional trustee of the other part. Now, from this, we come to know as to how and under which document ABC has appointed D as the new trustee. So that is how you read the devolution of title, by reading column 10 and 11 together. In column 13, if there is a grant given by the government, the details of that grant is given. In this particular example, the land had previously vested in the trustees of the improvement of city of Bombay. So when Bombay in 1800 was affected by plague, the colonial system at that point of time had formulated this trust, and there were several land vested in this trust for the purposes of upliftment of Bombay, which now, after the trust has dissolved, it is BMC which has come into place instead of Bombay, City of Bombay Improvement Trust. The details of the lease deed is mentioned in column 14. Now, in all these details, we often miss out the important column, which is the column 17 remark column. Now, you must be saying, oh, there is no entry mentioned over here. Why is she saying that it is an important column? In this particular property card, it may not be so. But most of the time, what happens is there is any mortgage, English mortgage or any other mortgage which is registered. If there is a reconveyance of the mortgage, if there is a setback what was the order of the statutory authority pursuant to which the setback area is taken away from my land. All those details you find under column 17, that is the remark column. Now we have seen the revenue records, the land records, property cards and all. So when you are doing a title investigation, it is necessary that you obtain certified copies, the latest certified copies of all these documents. The section 327 read with the rules gives you this opportunity to take inspection and take certified copies on payment of the prescribed fee. After looking at all this, there is the first question which comes, oh, then why do I do a document if I can just get my name on the mutation entry and that's the end of it? There was a lot of debate on this earlier in point of time, which is now at rest. The mutation entry, just because your name gets identified in a record of right, that by itself will never give you any title to the property. The courts have clarified where in one of the matter, a person was trying to prove his title to the land on the basis of the Satbara extract. The court clarified that these revenue records are important only for the purposes of the payment of the land revenue. However, you can use this record as evidence of the facts stated therein, but it is subject to rebuttal. You can always show a contrary evidence and disprove the case. Why it is important for the purposes of due diligence? Look, you've got so much of information. You've come to know who's claiming rights in the land. You've come to know how the title is devolved. With that basic information, you can dig in further by requesting for the documents, requesting for the mutation entry, and understanding the history of the land. Now we come to our next topic, that is the creation of charge by the company. Now, Chapter 6, Section 77 to 87 of the Companies Act 2013 states that whenever a company creates a charge or there is modification in the charge, for example, a company at the first instance created first an exclusive charge in favor of a ABC bank, and then there is some further dealing and ABC Bank is ready to share the charge on pari passu basis with XYZ Bank. Now there is a modification of charge so far as the ABC Bank is concerned. So that too has to be notified to the ROC within 30 days. If the company pays off all its debts, there is a satisfaction of the charge. Even that gets notified. That has to be notified to the ROC. What if the receiver is appointed by the order of the court, or for example, a manager is appointed under any instrument in respect of a particular property? That too has to be notified to the ROC. Now, when you notify all these things to the ROC, ROC makes note in the register in respect of those companies, and a certificate of registration of charge or modification or satisfaction gets issued by the ROC. So when you are dealing with a company, when your client is a company who's requested for the title certificate, or the other side who's selling you, the seller is a company, in that case, it is necessary for you to take inspection of the ROC records. It has now become very easy by way of just looking at the MCA portal, where all the records are digitized. Sometimes the records are not, in which case you have to take a physical inspection at the MCA office. The company is also required to maintain the register of the immovable properties and the charges which is created. You can always request such company to show you that register too, to satisfy yourself. There are heavy consequences if you do not register your charge. Because if the company goes into the liquidation, your liquidator or any other creditor of the company will not take into account the charge created in your favor. However, that does not release the company from its obligation to pay you money. It is still obligated to make the payment, and this issue has now been put to rest by several judgments, which have taken the view that if you do not register the charge with the ROC, it will not have any sanctity. If you do the mistake of not checking the ROC and you directly go ahead with the transaction, there is a deeming provision under section 80 where it says that if any person acquires any of the company's property, it will be deemed that he had complete knowledge of such charge from the date when this charge was registered with the ROC. We now come to the last topic that I will be covering, that is if your client is a trust, public registered trust under the Maharashtra Public Trust Act, or he is a seller, the trust is a seller. Similar like company where ROC is supposed to be notified, in this there is a Schedule 1 which is maintained by the Charity Commissioner. The Charity Commissioner will give you the names of the trustees. Now you have to identify better that all trustees are signing your document. So Schedule 1 will give you that information. Schedule 1 will also give you the information about the movable, immovable properties along with the descriptions. If there is any encumbrances, everything gets recorded in Schedule 1. Similar like the company Maharashtra Public Trust Act also has a deeming provision where if a person due to willful absentation or gross knowledge does not take all the hard work of checking the Schedule 1, he will be deemed to know about it. The trust also maintains the register of movable, immovable properties. You can always try to seek inspection of the same. And in order to obtain inspection or certified copies of any of the documents like Schedule 1, and if you are not person having interest, person having interest is defined under the Trust Act, that is in case of a charitable trust, a beneficiary or a trustee. Or if you are any other person, then you specifically require the permission of the Charity Commissioner for inspection and grant of certified copies. Fortunately, the Charity Commissioner has come into and entered the digital world, and they are digitizing their records. Previously, they used to scribble in the register, which was most of the time illegible. Now, at least we expect that the records will be properly maintained as per this format. So column 2 and 3 will give you the names of the trustees, the name of the trust. The second row will give you all the properties of the trust. And column 26 will give you encumbrances and the title deeds pertaining to the trust. With this, we have come to an end with regard to part 2 of the investigation of title.
Now, importance of title investigation. People over the time have become legally aware and knowledgeable, and hence the importance of title investigation of immovable property over the years has increased. Previously, there was a norm that